We will call the next case, which is Krolczyk. I apologize if I've mispronounced that, and I assume you'll correct me, versus Hyundai Motor Company. This is a 15-minute mini oral argument on the application. Ms. Liblang, you may reserve time, but we want you to manage that to the extent that's possible. And you may proceed whenever you are ready.
Thank you, Your Honors. Good morning. I'm Danny LeBlanc, and I represent Mr. and Mrs. Krolczyk, the appellants in this case. And I would like to reserve 5 minutes for rebuttal. The first thing you asked us to address in the supplemental briefing was whether the 46th District Court properly exercised jurisdiction when the order for transfer didn't have a stipulation to amend the complaint in it. And I think one thing with this question, I'm not sure I adequately addressed it in the brief, is that AO 1998-1 actually has two ways for the court to, if they're going to even apply that to a transfer under MCR 2.227, there's actually two ways. One way is to have the parties stipulate to the transfer and stipulate to an amendment, but the other way is for the court to determine to a legal certainty that the damages don't exceed the $25,000 jurisdictional limit. And in this case, the defendants actually prepared the stipulation, and we stipulated to the fact that the plaintiff's damages were less than the $25,000 jurisdictional limit. And we did that on a factual basis. We had a $14,000 mediation or case evaluation award. We had a vehicle that was a 2011. So it was 5 years old at the time we stipulated to this. It only cost $22,000 to begin with, and had 94,000 miles on it by the time we were stipulating to this. So the court could have looked at both the stipulation and the allegations in the complaint, which the administrative order says that it doesn't say you look at the addendum clause, because presumably any case in circuit court is going to have an addendum clause that exceeds the $25,000. But we're looking at should the circuit court exercise jurisdiction, or should it be transferred to a district court? And looking at the allegations in this complaint, plus the party's stipulation that the damages were less, I think the transfer was still proper, regardless of whether we had the stipulation in there formally saying amendment. I think that's somewhat taken as a given that we were going to amend when we got there. But importantly, the administrative order is really a procedural issue, which can be waived. And this court in Brooks versus Mamo mentioned that. That was that odd case that came on the cusp of when the legislature had repealed the law that allowed courts to just transfer cases, say after a low case evaluation award, over the objection of the parties. But back when we had that law, the district court still could render a judgment in excess of its jurisdictional limit. Once the legislature repealed that, a transfer meant that people would be giving up their right to get damages above the jurisdictional limit. And the problem was that courts were still using 2.227 to transfer cases over parties' objections and without hearings and so forth when they got the low case evaluations.
Let me interrupt you, counsel, so we can see what questions folks have. Okay. Time is limited. Justice Viviano.
No questions, thank you.
Justice Bernstein.
Counsel, good morning. What is your concern as it pertains to the jurisprudential significance? Do you anticipate this being a problem? If this court were to rule against you, what type of challenges would this present?
Well, I think one of the things is kind of illustrated by this case. We never even realized there was this order out there. And in fact, this was something brought up for the first time in the Court of Appeals sua sponte. So we complied with the court rule, but here we got this surprise that, oh, wait a minute, there's this administrative order that was really meant to address a different problem. And that was the problem of courts using the court rule improperly. And so it was essentially a clarification of how the court rule was supposed to be used. In this case, we weren't using the court rule improperly. And so I think one problem with it, unless the court rule itself is amended, is it's going to visit unfair surprise on litigants who think that they're complying when they enter into a stipulation, as we did in this case.
Counsel, thank you very much. No further questions.
Justice Clement,
Thank you.
Justice Cavanagh,
No questions for me.
Justice Welch,
No questions.
Justice Zahra.
Thank you. You made reference to the administrative order, and I think conceded that the first prong of the administrative order wasn't met. I understand defendant drafted the stipulation, but the stipulation only provided for the transfer, did not provide for the amendment of the complaint, correct?
That is correct.
So you go to the second prong, and from the allegations of the complaint, it appears to the court. So let's assume the court transferred it under that prong, okay? Then we get to the court rule, MCR 2.227. Transfer is permitted, but you still have to amend your complaint, right? So that you amend a complaint proper in the district court.
Correct.
2.227B, procedures after transfer, specifically gives the district court after transfer the jurisdiction and authority to allow an amendment of the complaint. And the district court, in fact, did that, correct?
That's correct as well.
And you amended your complaint, correct?
We did.
But you left in the complaint a prayer for relief in excess of $25,000. Is that correct?
It's correct as to the first amended complaint that we did after transfer. It's incorrect as to the second amended complaint that we did after transfer.
When was that second amended complaint?
The second amended complaint was filed after defendants raised this issue. The court then, under the statute and the court rule, allowed us to amend. So it was amended prior to entry of the judgment.
Okay, help me understand under what provision of the court rule it was appropriate for the court to allow that second amendment.
Well, under MCR 2.227B1, which was in effect at the time these proceedings were going on, there's no limit on when the district court has authority to grant a motion to amend, and presumably any case that's going to reach from a transfer from a circuit court to a district court, the original complaint is going to seek damages in excess of the circuit court's limit. And the only rule and only statute that gives us a time limit on the court's authority to issue an order allowing an amendment is 600.8301, which says correct it before judgment. You can correct any process or any pleading, anything it takes basically to correct a problem that really doesn't affect the rights of the parties. And in this case, all the lower courts agreed, the district court and the circuit court agreed that we tried this case as a district court case. We never sought damages, even in the pretrial summary that we submitted. We never sought damages in excess of the court's limit. We tried it as a district court case. Nobody even caught this. The defendant even answered our complaint, never caught this problem, or at least presumably never brought it to anyone's attention until it was time to enter the judgment after we'd done a 6-day jury trial and a multi-day fee hearing. So there's nothing in any court rule that I've uncovered, nothing in any administrative order, and nothing in any statute that abridges the district court's authority under B1 to go ahead and give the okay to amend the complaint. And I think importantly, under the statute, the 600.8301, I think the court was obligated to do that because it says the court shall issue whatever orders are necessary to correct a mistake in the interest of justice, certainly in the interest of judicial economy after we'd been through this lengthy trial and so forth and litigated for a couple of years in the district court.
I take it from your response, you feel a little bit ambushed by defendants' actions?
I absolutely do feel ambushed.
Right, and therefore you'd like to incorporate the bad faith provision of Hodge to support your claim. Is that a fair statement?
It's a fair state. It's not so much a bad faith, but an error. I mean, everybody recognized that this was a scrivener's error. It wasn't something that was done deliberately. And it would make no sense that after we stipulated, the circuit court accepted our stipulation, it would make no sense that then I could turn around and violate the rule that stipulations are sacrosanct once they've been accepted by the court, and then by an inadvertent stroke of my pen, divest the court of jurisdiction and have no way to correct that. And I think that's exactly the type of thing that 68301 was intended. It certainly wasn't bad faith. It was, it was a scrivener's error, but it was something
I want to focus on Hodge.
Pardon me?
I want to focus on the Hodge case.
Okay.
I have a little bit of concern that Hodge was really used to oust jurisdiction on the basis of bad faith. And here, I think you'd be implementing the Hodge decision to create jurisdiction or to support a finding of jurisdiction. Should I be concerned at all about that distinction?
I'm not sure I'm exactly following, so feel free to interrupt me if I'm not getting it. But in Hodge, I think the problem was that we had a lawyer that there were at least 3 cases that came to the appellate court's attention where they were filing what were clearly circuit court cases and filing them in district court, probably with the scheme to, boy, if we put, 150,000 in front of the jury, we'll at least get our 25. And I think, and certainly in the dissent in Hodge, one of the justices mentioned we should take a look beyond an ad danum clause when there's obvious signs that they're abusing the system. And so there was some criticism of Hodge of just saying we only look at the ad danum clause. And I think the later course, although it's not binding on this court, but the case involving, and the name escapes me, but it's cited in my brief, where it was obvious from the pleadings that the plaintiff who filed in circuit court, it was an attorney fee case against a condominium association, would never be able to prove damages in excess. And the court remanded it despite over objection. And they tried to argue that they couldn't do that. And the Court of Appeals said, yes, you can, if it's obvious from the pleadings. And so it's obvious from the course of procedure here where we stipulated to it, where you've got an allegation of a car that's 5 years old with that kind of mileage that didn't even cost $25,000 to begin with, that it really should have been transferred to the district court. And with defendant drafting this, I mean, it could have been what I mentioned earlier, is that we just weren't on notice that there was anything further other than the court rule to rely on when we were agreeing to the transfer.
I've taken enough of your time. I'll defer to my colleagues for further questions. Thank you very much.
Thank you.
And I might let you save your 222 for rebuttal, if that makes sense.
Okay, yes, it does.
Mr. LaVoy, you may proceed.
Thank you. Madam Chief Justice and Justices, may it please the court. There's one primary fundamental principle that I believe controls this case. The issues of subject matter jurisdiction that are implicated on this appeal I've seen variously described as black letter law, hornbook law, longstanding, and frankly uncontroversial. Indeed, this court just 5 years ago in that unanimous Hodge decision reaffirmed that jurisdictional amounts that either establish or preclude the exercise of jurisdiction are determined on the face of the pleadings. And in Hodge, this court emphasized that has been the rule of law in the state for over 160 years. There's no dispute of fact here that the parties and every lower court that has examined this case all agreed that on the face of the plaintiff's pleadings in the district court, it simply did not allege an amount in controversy that would vest jurisdiction in that court. As the Court of Appeals properly held, applying this court's decision in Hodge, that is itself sufficient to conclude that the district court did not have subject matter jurisdiction and really should end the inquiry. I think because this is a foundational doctrine of law that goes to the power of courts to exercise any authority in the first instance, pretty much the various arguments and challenges that appellants have raised in this case have all been rejected at various times under longstanding decisions of this court. So for example, lack of subject matter jurisdiction can be raised at any time. Parties cannot stipulate to jurisdiction where it does not exist, which is in fact directly contrary to appellant's argument here and in the lower courts that the prior stipulation somehow controls the jurisdictional inquiry here. Further, because courts either have or do not have jurisdiction, any order entered by a court that lacks subject matter jurisdiction is void ab initio. The court rules and the administrative order that we've been discussing here and in the briefs crafted by this court, I think, effectuate these principles of law. They serve a substantive purpose so that even when we are dealing with transfers between courts, jurisdiction will vest. That process was not followed here, but again, this is more than just a process error. There was a resulting substantive failure that really precludes jurisdiction in the district court. With that, I'd be happy to take questions from the court.
Thank you so much. Justice Viviano.
Yes, thank you, counsel. Is it fair to characterize what happened here as a technical defect in the pleadings?
It's not a technical defect, I think, because again, subject matter jurisdiction goes to a foundational principle of whether or not a court can exercise any authority over the case in the first instance. And
the parties stipulate as to the jurisdictional amount. So the substance of the matter, the parties agree, no?
Parties stipulated prior to the transfer, correct, but upon transfer, the first amended complaint that was filed by the plaintiffs in the district court continued to allege damages in excess of $25,000. I would also point out in a bit of rebuttal to opposing counsel's argument this morning, when it came time for them to file their motion for entry of judgment in this case, they in fact sought damages, a judgment in the amount of $51,575, in addition to 6 figures of attorney's fees and litigation costs. So they were seeking an ultimate judgment, almost $200,000, including damages alone of more than twice the jurisdictional limit in the district court. So it wasn't a mere technicality. I believe that, this is sort of enforcing the precedence of this court as to how subject matter jurisdiction is determined.
Let me ask you another question.
Yes.
What would prevent the district court from allowing an amendment to the complaint to conform to the proofs? Those are allowed in Michigan, are they not?
They are. I think two items in response to that. Number one, in Hodge, this court says you look at the pleading at the time that it's filed, sort of within the 4 corners, and absent, well, I guess the bad faith exception is a little bit of an open question, but even absent bad faith, you look at the pleadings and the pleadings control. So we're not supposed to look into whether there's clerical mistakes or good faith mistakes or no faith mistakes or whatever the case.
Would your client be prejudiced by an amendment to the pleading to conform to the proofs when your client stipulated already to that precise factual matter?
Yeah, Your Honor, it's a good question. I have read, I think, every subject matter jurisdiction case I can get my hands on in the state of Michigan by this point. Prejudice has never been a component of this inquiry. This is not supposed to be.
It's a component of the amendment inquiry, right?
Of the court rules and the statutes, and plaintiffs have not cited a single authority in any of the lower courts or in the briefing here that the statute that allows general amendments.
So you would say you can amend a complaint to conform to the proofs, but not to change the jurisdictional amount?
I think that this court was very intentional when it created AO 1998-1, that they created a process that would permit both the transfer and also a vesting of jurisdiction in the transferee court. We could stipulate to a transfer, but you have to then vest jurisdiction in the court, and that was the process that was not followed here.
I understand your legal position. I'm just trying to understand why you're saying we should not, or there should be some exception where you can't amend to conform to the proofs if it changes the jurisdictional amount. Is that what you're saying?
Well, I'm not saying that there can't be amendments later. What my position is,
your client can't claim prejudice here, right? Because you knew and agreed that this was the correct amount. It just was they failed to amend the pleading to reflect that, which ordinarily we would allow these types of technical defects to be remedied later because it doesn't affect the, the substantial rights of the parties, right?
Your Honor, I would agree with you as a general matter that ordinarily, yes, substantial rights of the party, prejudice, those things are relevant inquiries that should be examined. When it comes to subject matter jurisdiction, as far as I can tell, this sort of area of jurisprudence and standing are the two areas in all of Michigan jurisprudence where those types of things are not considered. Prejudice is not considered. Substantial, form, sort of substantial fairness arguments, excuse me, are also not considered.
We said in Hodge, and I don't have it right in front of me, but we said essentially that there is an exception for bad faith to this rule that we're going to look at the pleadings, right? So we already recognized one exception. What would prevent us from recognizing a second exception for these types of technical defects? Tell me all the terrible things that would happen if we were to do that.
Yeah, well, in Hodge, actually, the majority opinion, as I read it, does not recognize explicitly an exception for bad faith. Justice Markman wrote a concurrence where he sort of elaborated on his view of the law, and I believe in a footnote of the majority opinion, Justice Larson, who was then writing for the unanimous court, left it as an open question as to whether bad faith would be implicated. But opposing counsel has conceded here, as she did in the lower courts, though, that this is not a case of bad faith. I think the Court of Appeals appropriately sort of summarized the position that they're seeking a good faith argument or a good faith exception.
I just want you to address my last question now, and then we'll move on to other questioners. And so I'll just restate it. So in Hodge, okay, fine. The court didn't adopt or recognize a bad faith exception. The court sort of in a footnote acknowledged the possibility of a bad faith exception, which Justice Markman fleshed out further. So with that clarification in mind, what would happen? What bad things, if any, would happen if the court were to say today we're going to recognize an exception, another exception for a technical defect of the pleading, where the other party, almost by definition, I think, can't establish any prejudice because they stipulated to that amount? What would happen? What bad consequence would follow from that?
I think this court would have to essentially reverse its governing principle that was reaffirmed in Hodge and reverse the more than century of jurisprudence that has said that for purposes of determining jurisdiction, you look at the pleadings as set forth within the four corners of the complaint, and that's
a possible exception of a bad faith, right?
Correct.
We wouldn't have to reverse it. We could recognize an exception to it, is my point. Yeah.
Well,
all right, that's okay. I don't have any further questions. Thank you.
Thank you.
Justice Bernstein.
Counsel, good morning. Cases like this are always of concern to me because it gets away from the facts and the merits of the case, and it gets into in many situations, it can kind of get into some games that get played, and that always concerns me when you go away from the merits and you get into these types of issues. And I'd like you, if you could, to respond to Sister Counsel's argument that there was an ambush here, and I'd like you also to respond to the fact that this was quite a surprise to them, and ultimately going to a stipulation that you agree to. It's just, when you look at the face of this, I always think there's a certain way that we practice law that we're advocates, but it needs to be done in a certain type of a manner. And I'd like you to address that for me.
Yeah, thank you for the question, Your Honor. Opposing counsel raised the issue of ambush in particular as it related to the application of the administrative order 1998-1. I would point out that opposing counsel was actually the first entity, whether court or party, who relied upon that administrative order in the lower courts. As to the issue of surprise, plaintiffs are in control of their pleadings. It was their responsibility to file a pleading that conformed with the rules and that would vest jurisdiction in the courts. I guess more generally, and I certainly understand and appreciate the concern that this question raises. And my more general response would be that enforcing the rule of law. I mean, this is an area of jurisprudence, as I discussed earlier, that has been in effect in this state for more than a century and a half at this point, and enforcing the rule of law is in fact in the interest of justice. Enforcing precedents of this court is not a mere technicality or not an exercise in gamesmanship or surprise. This is a foundational doctrine of law that this court is now being asked to sort of modify or potentially affect in unknown ways that would implicate not just this case before the court today, but innumerable cases. Indeed, this doctrine has its fingerprints on every civil case that is filed in this state. So I can certainly think of other examples where by, for example, operation of a statute of limitations that's missed by a day, or a defendant who fails to plead an affirmative defense that can't rely upon it later, an at-fault party who might be for some reason immune and therefore escape his liability. All of those things might seem unfair, but courts under the rule of law don't change the rules midstream, in order to avoid an unfortunate result.
Counsel, thank you.
Thank you.
Justice Clement,
No questions. Thank you.
Justice Cavanagh.
Yeah, I just have one. I'm wondering if you can help me, because I'm struggling to understand why it is that Hodge applies, or why it controls this. I mean, Hodge is a completely different procedural posture, correct? And so we were deciding in the context of the facts, the procedural facts of Hodge, which I don't understand why that would control in a different situation in which a complaint was filed in circuit court. The parties stipulated to remand it to the district court. They tried it there. Why does Hodge control? It seems like we're picking a rule out of Hodge, or a statement, a principle out of Hodge that was under one particular procedural posture, and applying it, even though it seems to lead to a ridiculous result, in a completely different procedural posture. Why does Hodge control?
Sure, thank you for the question. I would agree with you that in terms of factually, Hodge is a factually different case. Procedurally, it's a different case. It's the principle of law, the rule of law, that I'm pulling from Hodge. The question before the court, as it was originally raised in the trial court and as it's been raised in the courts on appeal, is essentially how do we determine whether jurisdiction vests? And Hodge is the most recent example, and in fact, a very recent example of decisions from this court reaffirming the principle that you look to the amount of controversy as set forth in the plaintiff's operative pleading in order to determine the issue of subject matter jurisdiction, and therefore whether jurisdiction can vest in the court. So I frankly don't believe it makes much of a difference if that's as an initial matter or as here following a transfer from one court to another. You still have to look to the operative pleadings in order to determine whether the court that is being asked to take the case actually has the authority, has the subject matter jurisdiction to take the case.
Okay, thank you.
Thank you.
Justice Welch.
Thank you. No questions.
Mr. LaVoy, I want to follow up on Justice Kavanaugh's question. I also am struggling with why Hodge applies at all. As I know you probably know better than I do, having read all those subject matter jurisdiction cases, the rule of decision that was on the table in Hodge and is on the table in lots of cases is the front end subject matter jurisdiction question. Which court is the right place to hear this case? And we have lots of good reasons why the rule that we reaffirmed in Hodge, I think it's been the rule for a long time, about how we figure out which court is the right one to proceed with the case, why it makes sense. We don't want courts and parties to spend a bunch of time litigating that front end question, right? Here we don't have any front end question. We have agreement by the parties that the district court is the place where this proceeds. So the rule of law that I agree with you is an important one, and there are scholars that don't like this rule of law because they think it actually advantages plaintiffs who get to make this front end decision about where which court to hear their case. It doesn't implicate in my view, the stipulation by parties to jurisdiction. That's a concern that courts should have, because we don't want we don't want to allow parties to use us for legal rulings. So you don't want to an interest group to go in with a friendly government official and stipulate to jurisdiction so they can get some rule of law out of a court. That's not implicated here. So all of the reasons why we have the front end jurisdictional rule of law are not at all relevant in this case. I too don't understand what work the Hodge rule would be doing when the parties have stipulated that the circuit court is the wrong place and the district court is the right place.
Yeah, thank you for the question. There is law from this court as well that, again, stipulations cannot control jurisdiction. The Bowie case, Michigan Supreme Court 1992 decision, I think is one of the more recent ones there. And the Court of Appeals, I think, correctly addressed that issue in particular, that while parties can enter any manner of stipulations, this court in Hodge, reaffirming principles dating back to the Civil War era, says that you look to the governing pleading and essentially within the four corners of that pleading in order to determine whether subject matter jurisdiction exists.
But let me stop you. I mean, that's both of those principles are really important in the front end jurisdictional question. We don't want the parties to come in and stipulate that the district court or the circuit court can decide a patent law case, right? That's, these are important rules of decision for courts in exercising judicial restraint, frankly. What cases we decide and what cases we don't decide. How are they implicated when your client and the plaintiff have said, oops, the circuit court was the wrong place, the district court is the right place? How are any of those implicated? I know what the rules are and I know why they make sense. I'm trying to understand why they're implicated here.
They're implicated because the pleadings themselves, as I think this court recognized when it adopted the administrative order 1998-1, says not only is there a transfer from one court to the other, but you have to have an appropriate amendment of the complaint. It gets back to sort of the foundational principles, and I won't repeat them because you obviously recognize them, that, the governing pleading is the governing pleading, and it has to set forth a basis by which the court can exercise jurisdiction and authority. You are correct that, in fact, district courts are courts of limited jurisdiction. The Constitution vests authority in the circuit courts to try matters. The legislature has enacted a statute of limited jurisdiction for district courts. And so applying the principles that were most recently reaffirmed in Hodge, you get the conclusion that the mandate from the jurisprudence in this area that the pleadings have to conform, they have to vest authority within that court in order to exercise jurisdiction authority over a case.
Thank you. Justice Zahra.
Thank you. Mr. LaVoy, I have three questions for you. Let me start with the amendment to conform to proofs. As I understand that rule, there are times when a complaint might allege certain facts resulting in, say, for example, a premises liability claim. And then you get to trial, you present your proofs, and the proofs presented establish a premises liability claim, but they're not entirely consistent with what was alleged in the complaint. So you bring a motion to conform the pleadings, amend the complaint to conform to the proofs. Is that your understanding of the rule?
MCR 2.118, yes.
Okay. But here, it seems to me that the complaint alleges damages in excess of $25,000. And the proofs that were presented to the jury were that the damages were in excess of $25,000. And in fact, plaintiff attempted to obtain a judgment well in excess of $25,000, correct?
That is correct, yes.
So wouldn't it be fair to say the proofs actually conform to the pleading?
I would agree with that, Your Honor. And even after I raised the issue of subject matter jurisdiction in the briefing in the district court, the plaintiff continued to assert damages in excess of the jurisdictional limit. So even after this issue was expressly teed up, they still argued for that.
So you understand my concern about implementing this right to amend to conform to the proofs under the proofs that were presented in this case?
I do, yes. The proofs that were presented are actually consistent with what the plaintiff had pleaded in the original complaint and in the first amended complaint that was filed in the district court, which is damages that were in excess of the jurisdictional limit of that court.
Okay, I want to move on to Hodge. I read Hodge as saying when there's subject matter jurisdiction, but certain facts are in play between the parties, that we are going to create an exception and oust the court of jurisdiction. In this case, maybe perhaps on the basis of bad faith. It seems to me here there is no jurisdiction, and plaintiff is attempting to utilize Hodge to create jurisdiction. Should I be concerned about that distinction?
I think it is a good point. The rule of subject matter jurisdiction is whether or not authority can or cannot vest jurisdiction in a particular court. So as I read Hodge similar to how your question framed it, that it should not be used in order to create that essentially the bad faith exception cannot be used in order to create jurisdiction where it didn't exist prior, to the extent a bad faith exception exists in the first instance.
Okay, my final question, Ms. LeBlanc, I think raised a pretty persuasive point that the court rule 227B permits the district court to amend after transfer. And in fact, it was utilized once to allow an amendment, and the amendment, in my view, didn't do the job because they alleged a jurisdictional amount in excess of what the district court provided. But she responds, but there's no time limit in that rule. The rule says you can amend the complaint. The district court can allow an amendment of the complaint after transfer. So what's your response to that? Why wouldn't that court rule allow this complaint to be amended even at the later date of post-proofs?
Yeah, and on that, I would rely upon the case law that I cited in the supplemental brief, that because courts either do or do not have jurisdiction, any order that is entered by a court that does not have jurisdiction is void ab initio. So not even voidable or getting to prejudice or other factors, totality of circumstances test, things along those lines. It's just void ab initio. So if the district court did not have jurisdiction upon transfer from the circuit court here, it did not have authority in order to enter any order, whether it was an order for trial, a pretrial order, an evidentiary order, a judgment, anything, including additional amendments to the pleadings.
So by that reasoning, would not the first amended pleading filed by plaintiff in the district court also be void, notwithstanding the court rule that permits it?
That's the position that the Court of Appeals took, that because essentially the transfer was not effective and because there was not an appropriate amendment of the pleadings prior to transfer, jurisdiction never vested, and therefore that's why they remanded this matter back to the circuit court. They essentially said the circuit court never divested itself of jurisdiction because the pleadings were always within the circuit court.
Just so I understand, are you telling me that the first amendment of plaintiff's pleading, even though they alleged an amount in excess of $25,000, the first amendment after it went back to the district court that I believe was permitted under 2.227B1 procedure after transfer, that amendment was void? Even that court rule did not permit that amendment.
If you take the position of the Court of Appeals, then no, that no other orders or amendments were permitted. My position was slightly different earlier, that you can have a transfer, but you have to have an appropriate amendment of the pleadings to vest the transferee court with jurisdiction. And so under that circumstance, you could have an amendment after transfer. But that's a different position that the Court of Appeals took, applying this court's administrative order 1998-1.
Okay, thank you very much.
Thank you.
Thank you, Mr. LaVoy. Ms. LeBlanc, you have a little bit of time left, 2:20. You may use it.
Thank you. I think one of the things that we're losing sight here is that once we stipulated that these damages were less than $25,000, then I think the statute 68301 takes precedence and tells us that it should be in the district court. None of these court rules or statutes or even the administrative order puts a time limit on the amendment. And clearly the court rule, the 2.227, does contemplate that amendments are going to occur after the transfer. So in other words, the transfer itself allows the transfer to the district court. I haven't seen any case law, statute, or court rule that says that there was no jurisdiction of the district court at the time of transfer. So once it's there and the court rule allows an amendment, it should have been allowed to amend. And in fact, if we had caught the error at that time at the First Amendment, I think the court should have stricken that because it was in violation of the very stipulation that got us there in the first place. But I think importantly too, we've got 600.2301 that says at any time before judgment, the court at every stage of the action or proceeding shall disregard any error or defect in the proceedings which do not affect the substantial rights of the parties. So here, essentially what we had was a procedural error, but I don't think we had a jurisdictional error. And I'd like to correct some misconceptions that the opposing counsel says. What I had asked to do was take a judgment against the separate defendants for $25,000 or less, because there were two defendants. The court said no, because in your pleading, you said joint and several. So I'm going to limit it as to both defendants. So it certainly was not something where I was trying to get a judgment in excess of the jurisdiction. Had I not pled joint and several, the court certainly could have given me a judgment against each defendant within the limit. And the other thing is I think the defendant's argument is a little bit disingenuous when they filed a motion for new trial, claiming that my proofs weren't sufficient to support the jury verdict anyway, and claimed that they should have been less than the $25,000. That's what they say in their motion for new trial. But I think the real important issue here is there's really nothing in any of the law that says that the district court didn't have jurisdiction at the time that the case got there. It was really the only proper court to hear this case once we stipulated to the amount of damages. And that's certainly different than stipulating to jurisdiction. We stipulated to the underlying facts, that's how the jurisdiction then is determined. And once we have that, then I think the court was obligated to look at 2.227B1, at 2.118, and certainly at 600.2301 to correct an error that would have wasted 2 years of litigation, 6 days of trial, and 3 days of an attorney fee hearing.
Thank you very much, counsel. Does anybody have any additional questions? Thank you both. The case will be submitted.
All right,
Thank you.
you.